6 leasing fundamentals commercial. One of the key aspect of anything in commercial is a lease. Again, a lease is, is one of the primary things on the commercial side, and essentially leasing open opportunities as a specialty field in itself. Every type of property can be and has been leased, like residential garages, houses, apartments, offices, cottages, industrial space, retail space. And even the air rights over the buildings, railroads, subways, and all of these can be leased. In this chapter, we're going to talk about uh, the commercial and residential tenancies with specific emphasis on the principal use and applicable legislative considerations, distinguishing between a license and a lease, outline the key considerations in commercial lease, including the topics such as assigning, subletting, continuous use, and dark space, fixtures and trade fixtures, guarantor versus indemnifier, interest on deposits, non-payment of rent, quiet enjoyment, rent increases, restricted use, rights and obligations, and termination provisions, identify and the essential components of a typical commercial lease, including base lease and the city schedules. We also will look into commercial leases, including the gross and net percentage leases, along with detailed discussions on the base and additional rent. Outline the key concepts involved in the commercial floor measurements, including BOMA standards, rentable and usable areas, the rentable by usable factor, R by U factor, and common area maintenance, also called a scam. We'll discuss about the commercial rent related topics, including advanced tax payments, supplementary rent pass-through, and rent concessions. And also we'll discuss the role of property manager with reference to management agreement, maintenance plans, budgeting, insurance, security, and property management and tenant relationship. So let's dive deep into it. So in the area of the area of commercial tenancies, can be generally described as any property subject to a leasehold interest that describes the land and buildings used for any business activity. Commercial tenancies are governed by the provisions of the Commercial Tenancy Act. The, the, the name of the act was previously Landlord and the Tenant Act, Part 123, and formally changed in 1997. Part 4 of the Landlord Tenant Act was repealed and replaced with a separate but more inclusive Tenants Protection Act 1997, which essentially was amended to the current Residential Tenancy Act. So the commercial tenancies are complex for various reasons. Commercial properties are inherently diverse and require specialized wording related to industrial, office, retail, investment, and vacant land leases. Requirements concerning such tenancies require an interplay of legislative as well as legal precedents. In fact, debate concerning commercial lease can require detailed review of legislative requirements and the principles set out in the contract law case law. So the structure of Commercial Tenancy Act is somewhat disjointed in comparison to the residential counterpart. There are three parts to it. Part 1 generally addresses the landlord and tenant relationship. Part 2 focuses on restraint, seizing and holding goods for areas in rent. And Part 3 concerns overholding tenants. So the the so an important consideration here is whether the tenancy is a commercial tenancy or a residential tenancy. The line between the commercial and residential tenancy is often blurred by the legislative consideration impacting both landlords and tenants. The residents must first look to the Residential Tenancy Acts to gain a full perspective on the issue of whether the lease falls to the Residential Tenancy Act or to the Commercial Tenancy Act. The the commercial lease can be identified as any lease involving property that was principally used for the business activity. The word principally is to be emphasized here, as in most cases common sense prevails. For example, a small home office with a residential structure will not affect the residential status of the property. A structure containing a main level commercial enterprise and the two upper apartments would be identified as a commercial for the lower unit and the residential for the upper unit. Certain hybrid situations can cause problems. For example, consider a tenant renting a home located on a 30-acre rural residential property and also renting the barns and balance of the property as a riding stable. If the individual occupied the home prior to riding stable operation and lease a business operation under a separate lease, and the Tenancy Act will not only apply to the residential tenancy. If the person became the tenant coincident with the renting of the barn for riding stable operations under a single lease, in other words, occupancy of the house was required to carry carry the business, the property would be unlawfully be judged as a principally used for commercial purposes. Establishing whether residential commercial tenancy can have a significant impact, particularly with regards to the notices concerning termination, rent charges, and right of access for the landlord to show the property or to make repairs. So let's look into what is a lease. What is the agreement to lease? Agreement to lease is technically referred to as the agreement for lease without a settled form of lease. As such, a document sets out the fundamental material aspect of the agreement between the parties, but contemplates the execution of a formal detailed lease. An agreement to lease offers covers substantial issues and is best described as the consequences leading to a final agreement or settled form of lease. In that way, the typical lease negotiations involve two steps: the agreement to lease, followed by signing of a formal lease. The agreement to lease must include all essential elements of the lease, namely the parties, description of the premises to be leased, the commencement of the lease, the term of the lease, amount of the rent, all the other material matters in the lease other than the specific exemption reservations, covenants, and special conditions and applied by the law. The agreement to lease must also address all the material issues in order for that the lease can be correctly withdrawn as a consequence of the agreement. So let's look at what is a in most cases a blank copy of the lease must be attached to eliminate any confusion and ensure that the tenant fully appreciates the true scope of the document. Landlords dealing with the complex leases often require this procedure. License versus lease. A license is a right or a permission granted to an individual, while a lease is both a matter of or contractual arrangement and also a conveyance of the stated land. While the dispute regarding such matter falls to the judicial interpretation, the court generally look to the issue of whether exclusive possession has been given and whether signed agreements are couched in terms usual to the lease. Landlords, lessor, tenant, lazy, lease, demise, premises. However, other factors beyond can also be considered. So again, to recap, a license is a right or a permission granted to an individual, while a lease is both a matter of contractual arrangement and also the conveyance of a stated land. While a dispute regarding such matter falls to judicial interpretation, the court usually look to the issue of whether exclusive possession has been given and whether signed agreements are couched in terms usual to the lease. For example, landlord, lessor, tenant, leasing, lease, and the demise premises. Commercial tenancies. What are the administrative and legal issues? Assignment and subletting is one of the critical items, followed by continuous use and dark space, trade and fixtures and trade fixtures, guarantors in was identified interest on the rent deposit, non-payment of rent, quiet enjoyment, rent increases, restrictive use, rights and obligations, and the termination. So let's look at these aspects one by one. So assignment and subletting. The legal decision between assigning and subletting in a commercial lease is based on the privity. Privity generally refers to the legal propositions like contract, including the rights and obligations, is only enforceable upon the parties to the contract. So to again separate it, assigning and subletting in commercial lease is based on the notion of the privity. Legislators need not fully understand the legal complexity associated with assignment, subletting priority, but should be aware of the basics. At the end of the lease term, the tenant is required to to reconvey the leasehold interest to the owner of the freehold estate. This creates a privacy of estate between the tenant and the landlord. If, for instance, the tenant assigns all of its lease to a third party, the third party, known as assignee, has established a privacy of estate with the owner or landlord. The former tenant or signer of the lease has no privacy of the estate remaining with the landlord. On the other hand, if the tenant conveys a portion of the leasehold to a third party, such as tenant retains a period of time at the end of the term, then the tenant remains privacy of the estate relationship with the landlord. The subtenant so created would have no privacy of estate with the landlord. To recap, so if a tenant conveys a portion of its leasehold estate to a third party, such that the tenant retains a period of time at the end of the term then the tenant remains in the privity of state relationship with the landlord. Subtenants who created have no privity of state with the landlord. In case of assignment, the assignee and the landlord may have the privity of contract, provided the assignment to the assignee includes the language to the effect that all the benefits and the burdens of the lease is assumed by the assignee. In that case, the obligation to the landlord flow through to the landlord, and the privity of state continues between the landlord and the assignee. The landlord also retains his priority of contract with the original tenant unless otherwise agreed. Typically, the tenant commercial lease is not typical tenant commercial is not permitted to sublet, assign or transfer its interest in the lease without securing a written consent of the landlord, which consent cannot be unreasonably withheld for the provided the tenant shall remain liable for all obligations under the lease. Subletting in a contractual context, if the tenant sublets his premises, no privity contract exists between the occupant and subtenant and the contract. Therefore, the landlord will not have any legal relationship in the form of privity of state. And the contract with the occupier of the premises, however, the landlord retains his privity of contract and the state with the original tenant. Accordingly, the lease normally provides that a subtenant must directly covenant with the landlord in order to ensure that the landlord may then pursue its action against the tenant and the subtenant. So to recap, us in a contractual context, if the tenant sublets its premises, no privity of contract exists between the occupant, subtenant, and the landlord. Therefore, the landlord will not be having a legal relationship in the form of privity of a state contract with the occupier of the premises. However, the landlord retains a privity contract instead with the original tenant. Accordingly, the lease normally provides that a subtenant must directly covenant with the landlord in order to ensure that the landlord may then pursue its action against the tenant or the subtenant. Preparing lease provisions. Landlord should be careful in preparing the assignment and subletting provisions of the lease. In the first instance, the landlord should require that any assignment of subtenant is subject to the landlord consent and that the new party, be it assignee or subtenant, must agree to the covenant directly with the landlord in respect to the tenant's obligation present to the lease. Accordingly, the former tenant would not be released by the landlord unless the landlord, for other reasons, may elect to do so. The landlord is entitled to withhold its consent only on reasonable grounds. For that reason, many commercial leases allow landlord, when faced with the assignment or subletting situation, to terminate the lease. This gives the landlord certain control over the premises, particularly in a stronger market. The rent chargeable at the time of the assignment or subletting is substantially higher than the currently being paid by the existing tenant. Further, the landlord often includes a provision whereby the tenant is not permitted to sublet or assign the premises and receive rent higher than what would have been otherwise be payable to the landlord pursuant to the lease. The tenant, from the landlord's perspective, should not be in a position to obtain extra funds should the demand for the rental space increase after the execution of the original lease. The landlord should also take care of the time of assignment of the building to be ensure that adequate documentation is in place to ensure sufficient covenants from the new assignee or tenant, as well as preserving the right to pursue any or all legal remedies against the original tenant. Continuous and dark space. This requirement frequently is found in the leases, which require that the tenant must continuously occupy the rented space during the currency of the lease. Typically, a continuous use clause is accompanied by covenants that the tenant will retain the substantial merchandising stock and fully staffed operations. Landlords are increasingly concerned with the dark space if the lease does not contain a continuous use clause. The tenant may move out of the premises while continuing to pay rent. Landlord might be left with a dark space in the retail center, which cannot be related to a third person. Landlords have found it necessary to include a continuous use clause in the lease, particularly with respect to large tenants. Fixtures or trade fixtures. Commercial leases often refer to tenant fixtures or, or trade fixtures. The general theory under common law was that any fixture belonged to the person who owned the real estate. Therefore, the landlord would own the buildings and the landlord would also own any fixture which was a part of the building, whether the fixture was placed by the tenant or not. Common law further developed to permit the tenant to remove such fixtures from the real estate as were necessary for it to conduct its business. Such fixtures became known as over time as the trade fixtures. Unless the lease states otherwise, the tenant who affixes the item to the realty is entitled to remove that item at the end of the term if that item is necessary for the tenant to carry out its trade. The difficulty arises in that particular item may in one situation be a trade fixture while not being another. Most leases provide that any fixture fastened to the rear yards to become the property of the landlord at the time of the fixation. After the lease term is expired, provided that the landlord has paid all the rent, tenant may remove only the trade fixtures. Landlord may insert a provision in the lease to ensure that the tenant may not take goods unless all the rents have been paid. Also, the landlord may provide in the lease that tenant, at the landlord's opinion, may be required to bring the premises back to its own original condition, bare walls and floors at the end of the term. This represents a substantial labor for the landlord at the end of the term, as the necessary repairs may be costly for the tenant. Tenants should exercise caution regarding such provisions in the lease, or or at least be aware of the costs stated with the removal of the items at the end of the term. Commercial leases may also provide that the tenant repair the premises when the tenant fixtures are removed at the end of the term. Further, the lease obtain may include a provision outlining the implication of the tenant leaving the goods on the premises for any considerable period after the end of the term. Guarantors versus indemnifier. The distance involved with commercial lease often encounter landlords' requirements concerning guarantor versus indemnifier. In a leasing, a guarantor is requested to sign appropriate documents assuring that the landlord that in the event of a default he or she is responsible for the default of the lessee. Landlord may request that an individual agree to an indemnification agreement rather than simply being a guarantor. A person signing an indemnification agreement becomes an indemnifier, as as such he or she holds the broader scope of liability. Historically, a landlord would seek a guarantee when the corporate tenant lacked sufficient assets to fund any default. However, such a guarantee such a guarantee involving a third party is limited as it acts only to the tenant obligation. If the tenant is deemed by law to have no obligation, then the guarantee is released from as well from its obligation. For example, if the tenant is adjudged bankrupt, then the tenant has no ongoing obligation for the lease, or the guarantor has simply guaranteed the obligation of the tenant, and the tenant becomes bankrupt, then the guarantor is not required to pay as the tenant no longer has a liability pursuant to the lease. Indemnifier has grown in popularity. This arrangement provides that the indemnifier agrees to indemnify and hold harmless the landlord against any damages that may result from the tenant's failure to perform its obligation pursuant to a lease. Indemnity agreement normally go further and imply that the indemnifier is a covenanter person to the lease in the same sense as the tenant, and that this indemnity survives any bankruptcy, insolvency of the tenant. Such agreements also typically provide that the indemnifier, upon failure of the tenant to perform the pursuit of the lease, is deemed to be the tenant and is subject to all covenants contained in the lease. Accordingly, the prudent landlord will have, where appropriate, an indemnity agreement in place with the proposed guarantor as opposed to the state guarantee. Accordingly, a prudent landlord will have, where appropriate, an indemnity agreement in place with the proposed guarantor as opposed to the state guarantee. Interest on rent deposits. Under the Commercial Tenancy Act, the landlord is not required to pay interest on the commercial tenancy security deposit. However, a lease agreement may otherwise require it. Non-payment of rent. When the tenant has failed to pay the rent, the landlord has two options under the Commercial Tenancy Act. So, option number one is to change the lock, and option number two is to seize and dispose of the tenant property. Let's look at option one: change the lock. A landlord may change the lock of the unit and evict on the 16th day after the rent was due. The landlord is now obligated to notify the tenant that the lock has changed. For example, if the rent was due on January 1st, then the lock can be changed without notification on January 17th. As a cautionary note, the landlord and tenant should not force their way into the premises. Also, the locks have been changed. After the locks have been changed, the landlord should allow tenant reasonable access to the rental unit to remove their property. Seize and dispose of tenant property. A landlord may seize or dispose of the tenant property that is contained within the rented premises. The landlord is not required to give advance notice of seizing tenant property unless the lease provides for such notices. However, the tenant are required to notify the landlord of the distress, and the sum of money is required to cure the default before proceeding to seize the property. By disposing of the seized property, the landlord must hold such property for 5 days. If the proper payment is made by the tenant in 5 days, the landlord is not permitted to sell the tenant property. Otherwise, after the proper appraisals has been made, the property can be sold. Landlord and tenant are advised to seek legal advisors. Quiet enjoyment. The quiet enjoyment refers to non-interference by the landlord with the where the tenant occupation of the premises, which generally protects the tenant from any direct or indirect action or threatened action by the landlord that disturb the tenant. Great essential. So essentially, quiet enjoyment refers to non-interference by the landlord and tenant's occupation of the premises, which generally protects the tenant from indirect or indirect action or threatened action by the landlord that disturb the tenant. But extent should extend due caution in all matters concerning the topic. Quiet enjoyment does not mean undisturbed noise or other disturbances, sound or order from during tenant temporary maintenance activities by the landlord or innovations or by the landlord. If the landlord effectively deprives the tenant of the use and enjoyment of the rented premises, a breach of covenant can result. The breach, if significant, can effectively result in the constructive eviction, which can entitle the tenant to abandon the premises and not pay rent, which can entitle the tenant to abandon the premises and not pay rent. Constructive eviction can basically happen if the tenant is not having the quiet enjoyment. Essentially, the tenant entitles the tenant to abandon the premises and not pay rent. That said, the rights should be aware that the issues concerning quiet enjoyment the right landlords are complex. Most regarding the rent increases, most commercial tenancy agreement outlined uh, um, the amount of rent charged and the frequency of the rent increases. The Commercial Tenancy Act does not regulate the rent increase, as is the case with residential tenancy and the Tenancy Act. Restricted use. Restricted use is a clause within the lease that limits or in some way restricts the activities that of either landlord or tenant pursuant to the lease agreement. The landlord may insert a restrictive covenant regarding a specific use. So to recap, a restricted use, the landlord may include a restricted clause to ensure proper mix of tenants should apply to lease terms or renewals premises to be enjoyed by signing an expansion. Let's look at right an obligation of tenant and landlord. The landlord has to notify tenant of a breach and allow a reasonable time, has the right to terminate the tenancy, and has the right to apply to the superior court or monthly for damage or loss of property income. Tenant must pay rent on the due date and cannot withhold rent because the landlord failed to fulfill obligation. Has the right to take a dispute to the small scale court termination. In the case of month-to-month, a 1 month written notice is required. Landlord and that notice should have the landlord name, tenant name, address, date of the notice, and date of the termination. In the fixed term tenancy, penalty of 2 month rents for every month. And in addition, there is a notion of that we have to get a eviction order. So to recap, in the fixed term tenancy, the tenancy specifies the length of term of the lease. And under the Act, once the tenancy ends, the tenant no longer has the right to occupy the premises. For example, under the three-year lease agreement, tenant is expected to lease the premises at the end of 3 years. If the tenant continues to occupy the rental premise after the tenant has requested tenant move out, then tenant may be subjected to penalty of 2 months' rents for every month that remains on the premises plus applicable costs. In addition to the imposing financial penalty, the landlord may also apply to Ontario Superior Court with justice to obtain an eviction order. Lease component, the base lease. A base lease is a standard contract prepared by the landlord, applicable to all the tenants in a specific complex. Now it contains the minimum rent, services provided, allocation of common areas, and elements are name of all the parties, description of the lease premises, statement of consideration, legality of the use, commencement and expiration dates, and the rights and obligations of the parties, which are like restrictions or additional costs or exclusive covenants. Now, the lease also contains a bunch of schedules. So Schedule A is contains the premises, which has like a building plan, and um, and which has a building plan, floor plan showing exact configuration of the lease premises or mechanical details for the tenant, interior designer, or architect for approval by the landlord, and it has Schedule B, which is plot plan or site plan, which is the overall land, and its sizes and the dimension, access or egress, egress systems, boundary roads, highways, parking, loading deck, and such light facilities, and and also has a landlord and tenant work, which is Schedule C, and the rules and regulations, which is where the governing operations, including maintenance agreement, agreeing to not to undertake certain activities, store and store opening and closing before the after the stated hours. Like now, looking at the type of commercial leases, there's a gross lease, net lease, base and additional rent, and and the percentage lease. And now, in case of a gross lease, the tenant pays a fixed amount, and owner pays all the operating expenses associated with the property. In case of a net lease, the tenant pays a portion of the expenses associated with the lease promises. And again, the net lease is like there's a net lease, there's a net lease, and then there's a triple net lease. Now, in the case of in the case of gross lease, the tenant pays a fixed amount, and owners pays all the operating expenses associated with the property. In the case of a net lease, tenant pays a portion of the expenses, and that portion of the expenses is kind of determined by the type of net lease. If it's just a plain net lease, the tenant pays rents and certain different expenses. In the case of a net lease, tenant pays maintenance or operating expense and the property tax, but excludes any structural expenses. And in the triple net lease, the tenant pays all the expenses, and this is in addition to the rent, base and additional rent. And in the type of commercial lease where it's a base and additional rent, the the additional rent contains only rechargeable items like operating costs, property tax, and property tax and utilities, and is not capital oriented or structural. As a part of base and additional rent, there is a base rent component and there is an additional rent component. And additional represents the proportionate share of the operating cost estimated at the commencement of the year and payable in installments. But if the taxing authority wants full payment, then the additional rent will account for that. In 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 the cases of base and additional rent, there is a statement of additional rent that is provided by the landlord at the end of the year, or rather within 3 months at the end of the year. And in case of percentage lease, especially more common in the retail sector, tenants must pay a fixed minimum rent and a percentage of the gross monthly income in excess of the base sales, calculated using the minimum rent. For example, let's say there's a 3,000 square meter of a supermarket, and the percentage rent is 1.25 to 1.5%, and the base and the base rent is or the minimum rent is 120 per square meter. Then the sales has to be in excess of 24 million for the percentage rent to kick in. Various rates of percentage rent reflect the mark on the retail side. Certain retail exclude the low maintenance, low margin items. For example, hardware store, for example, some pharmacy store will not will remove the sales of low margin item such as tobacco, and like also like the percentage leach percentage like 1.25 to 1.5, that is low on the hardware business but high on the BDSL business because of the other markup involved. Measurements and rents, like building owners and on management association develop a standard method for the floor area. It could be the gross building area, gross leasable area, rentable area, usable area, rentable by usable factor, and common areas. With regards to the rent-related topics, we have to understand that there's an advance rent payment that can happen. There's supplementary rent that can be added. There's a pass-through. There's a rent concession, And with regards to property management, essentially means the property leasing, rent collection, paying expenses, and maintaining the property. There is a management agreement which sets out the roles and responsibility of the owner and property manager and contains key elements. There is a maintenance agreement as well, an orderly upkeep of the managed property. There is budgeting, the annual net operating income projections, monthly and net operating income projections, and then also there can be like annual or monthly cash flow budgets, insurance and security, and other aspects here. Also, we need to look at the property management and tenant relationship. I think with this we are done. Thanks for your time. Bye.